Trump's tariffs face major court test. What's at stake for U.S. trade policy? The impending court case regarding President Donald Trump's tariffs is a pivotal moment that could determine the future of his controversial trade policies. On Thursday at 10 a.m. Eastern Time, a panel of 11 judges in Washington, D.C. will hear arguments for approximately 45 minutes from both the Trump administration and two small businesses that contend many of his import duties are unlawful. These tariffs, which are scheduled to take effect on Friday, have been a source of significant debate. After delaying the most substantial increases in April due to market instability, Trump has since outlined various tariff levels affecting around a dozen trading partners. While many of these rates mirror those he threatened to impose earlier in April, some have been adjusted upwards, while a few have been slightly reduced. Businesses of all sizes have expressed that these tariffs have led to confusion and uncertainty, complicating their ability to plan effectively. The National Retail Federation highlighted this issue in June, stating, "Retailers typically plan their inventories 6 to 9 months in advance to meet seasonal demand. However, unpredictable and rapidly changing tariff policies are making it nearly impossible to forecast costs, place orders, and manage supply chains effectively." VOS Selections, Inc., a wine and spirits importer, along with Plastic Services and Products, a company specializing in pipes and fittings, have taken legal action against Trump. They argue that his implementation of tariffs under the International Emergency Economic Powers Act, IEEPA, of 1977 is unauthorized without congressional approval. In late May, the Court of International Trade initially blocked these tariffs, determining that the import duties lacked any identifiable limits, and that the law cited by Trump in his executive orders did not grant him unlimited tariff authority. The court also concluded that the tariffs did not satisfy the criteria for an unusual and extraordinary risk to the nation. Trump's tariffs, which have been applied to major trading partners including Canada, Mexico, China, the European Union, Japan, India, and Brazil, have been enacted under this law. The companies involved in the lawsuit assert Congress has not delegated any such power. The president's justification does not meet the standards set forth in the IEEPA. His claimed emergency is a figment of his own imagination. Trade deficits, which have persisted for decades without causing economic harm, are not an emergency. They further argue that the IEEPA does not mention tariffs, duties, imposts, or taxes, and no other president has claimed that it authorizes tariffs in its nearly 50-year history. In response to the case, the White House stated in May that trade deficits have created a national emergency that has decimated American communities, left our workers behind, and weakened our defense industrial base. It's important to note that this court battle will not impact tariffs imposed under different laws, such as the 10% steel tariffs on the United Kingdom and the 50% tariffs on steel and aluminum affecting other global trading partners. These tariffs were enacted under various sections of the Trade Act of 1974 and the Trade Expansion Act of 1962. The companies involved in the lawsuit also warn that such sweeping tariffs could be devastating for small businesses across the United States. While the panel of judges is not expected to deliver a ruling this week, it is likely that whichever party loses will appeal to the Supreme Court. This ongoing uncertainty has left consumers and businesses in a precarious situation for much of this year. Moreover, this lawsuit is just one of many challenges facing Trump's tariffs and trade agreements, with at least a dozen other lawsuits either filed or in the early stages of litigation. In a related case filed this month, an orange juice importer cautioned that prices for its products could increase by as much as 25% for U.S. consumers due to Trump's proposed 50% tariffs on Brazil, which he justified by citing a trade deficit that is in fact a surplus. This steep tariff appears to be influenced more by political considerations regarding former Brazilian President Jair Bolsonaro and the treatment of tech companies, particularly Elon Musk's X. Even if the court rules against Trump's tariffs, the administration may still explore other options to maintain them. For instance, Trump could direct the Commerce Secretary and the U.S. Trade Representative to initiate investigations under Section 301 of the 1974 U.S. Trade Act against various trading partners, which would allow for tariffs to be implemented following the completion of these investigations. Additionally, he could utilize Section 232 of the 1962 trade law, which is already in effect for steel and aluminum duties. There is also a rarely used trade law, Section 338 of the Trade Act of 1930, which permits the president to impose tariffs of up to 50% on imports from countries that discriminate against the U.S. According to Alec Phillips, chief U.S. political economist at Goldman Sachs, this authority has never been utilized before and does not necessitate a formal investigation. In an insightful essay on trade issues, Max Yoli from the UK think tank Chatham House and Leslie Vinja-Murray, president and CEO of the Chicago Council on Global Affairs, suggest that Trump could collaborate with Congress to enact new legislation that would provide additional tariff authorities. However, they note that his administration has shown a strong preference for executive action thus far. They also point out that the president has various tools at his disposal to influence states and achieve his objectives, including the expansion of sanctions and export controls. While Trump could negotiate and finalize formal trade agreements, most of what he has labeled as deals so far are not comprehensive pacts. Instead, they tend to be framework agreements that lack detailed provisions, often announced via social media and followed by minimal executive orders. However, it is crucial to understand that formal trade agreements typically require years to negotiate due to the intricate nature of both the U.S. and global economies. The United States alone has over 12,000 potential tariff categories across 200 trading partners, as reported by the financial services firm UBS. Any formal trade deal could be approved by Congress without the need for court intervention. Correction, July 31st, 8:31 a.m. ET. A previous version of this article incorrectly stated the location of the Federal Appeals Court panel hearing arguments on Thursday. The correct location is Washington, D.C., not New York. Court skepticism on Trump's tariffs. Legal battles unfold. Judges express doubt over the legal foundation of Trump's expansive tariffs. In a significant legal challenge to the Trump administration's trade policies, a panel of appeals court judges expressed serious reservations about the justification for broad tariffs declared under a national emergency. With the looming August 1st deadline set by President Donald Trump for the reinstatement of reciprocal tariffs, the U.S. Court of Appeals for the Federal Circuit convened on Thursday to deliberate on the legality of these tariffs. This case has garnered attention as a group of small businesses and a coalition of states have petitioned the court to nullify a large portion of the tariffs, asserting that President Trump exceeded his constitutional powers by invoking an outdated economic emergency statute to implement a series of tariffs in April. The president's erratic use of this claimed authority, which shifted daily and caused significant disruption in financial markets and the broader economy, highlights both the extent of the powers the president asserts and the peril of unchecked authority in this area. The coalition of states contended in their court documents. At the outset of Thursday's hearing, the judges on the panel probed the rationale behind Trump's reliance on a law that has never been utilized to support tariffs, noting that the legislation does not explicitly mention tariffs. They also raised concerns that the president's invocation of emergency powers to justify unilateral actions could signal a fatal blow to the Constitution. This hearing is particularly timely as Trump scrambles to finalize trade agreements before a self-imposed Friday deadline for the re-implementation of numerous reciprocal tariffs. Attorneys representing the Trump administration have contended that a court ruling to invalidate the tariffs could result in a disastrous foreign policy scenario given the ongoing trade negotiations. In a tweet on Thursday morning, Trump rallied his legal team, stating, "To all of my outstanding lawyers who have worked tirelessly to safeguard our nation, best wishes in today's major case for America." If our country couldn't defend itself by imposing tariffs in response to tariffs, we would be doomed with no hope of survival or progress. The legal grounds for Trump's tariffs came under scrutiny in May when the New York-based Court of International Trade ruled that the president lacked the authority to unilaterally impose Global Liberation Day tariffs, along with tariffs on China, Mexico, and Canada aimed at curbing fentanyl trafficking. However, a federal appeals court swiftly issued a stay on the Court of International Trade's decision to prevent it from taking effect while the Trump administration's appeal progressed through the judicial system. The central question before the court is whether Trump had the legal right to impose tariffs without congressional approval under the International Emergency Economic Powers Act, which grants the president the authority to levy tariffs in response to an unusual and extraordinary threat. While the Trump administration maintains that the tariffs are necessary to combat fentanyl trafficking and address the nation's trade imbalances, the Court of International Trade was unconvinced that the administration had demonstrated an unusual and extraordinary threat, and that the tariffs effectively mitigate these threats. In court documents, the Trump administration has argued that the ruling is fraught with legal inaccuracies and would severely damage the United States if implemented. They justify the tariffs by pointing to the fentanyl crisis and the serious threats to the United States' national security and economy posed by trade imbalances. President Trump has determined that America's escalating trade deficit, its impact on our economy and national security, and the fentanyl crisis, which has claimed thousands of American lives, constitute national emergencies. The Department of Justice's lawyers have argued. The administration further contends that invalidating the tariffs would strip the United States of a potent instrument for addressing systemic distortions in the global trading system, thereby allowing other countries to continue to exploit American exporters through their unfair, discriminatory, and often retaliatory trade practices. However, the coalition of small businesses and state attorneys general counter that the International Emergency Economic Powers Act does not confer unfettered tariff authority to Trump, and that he has not substantiated an unusual and extraordinary threat. But here's where it gets controversial. Critics argue that the president's actions have not only destabilized markets, but also set a dangerous precedent for executive overreach. What do you think? Should the president have the power to impose tariffs unilaterally, or should this authority be more closely regulated by Congress? Share your thoughts in the comments.